Good evening, everyone. Quick audio visual check before we begin. Can you guys type, can any of you type in the chat box that yes, I'm audible and I'm visible? Okay, great. Thank you, Anushri. Thank you, Sindhija. Welcome to the session. Good evening. Yes, Tanisha is saying AV. Okay, great. Good evening, everybody. Good evening, Anusha, Harsh. और कौन आया है? तनिषा, सिंधुजा, अनुश्री. Okay, welcome everybody. ठीक है. How's everybody doing? Hasika, good evening. Anna, great. Chalo, good evening, everybody. Hi Yash, chalo. Ayush, great. और कौन है यहाँ पे? और भी other people are adding on. Chalo, good to see you guys here. Welcome to the session. ठीक है. And as the slide says, today's session we are going to touch upon a certain topics which are covered under the current legal knowledge for CLAT and AILET. You know, there's this entire demand which has been coming to me of late कि ma'am current legal में क्या आएगा, considering the fact that we have seen the sample papers are based on miscellaneous things which are maybe not always conventionally coming in the CLAT exams, right? So keeping in mind the pattern which is there in the sample papers, I've tried to cover a handful of topics here. We'll do them in a little bit of detail so that you have a clarity agar passage aaye, right? Now, so when we are looking at this particular class, remember that I'll try to cover more and more topics each Thursday now. So, so we have about 3-4 Thursdays before your final exam is there. So what I'm thinking is, instead of, picking up topics from here and there, what we are going to do is we are going to pick up important things which have happened over the 1 year time in the legal scenario and how it can come in your exam. What kind of passages can be really framed in those from those topics. Okay? So we will start today with that. Okay. Now, so the first thing that we have on our agenda today is is marital rape. Okay, so what we have, the first thing is on marital rape. Again, very 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 hot, in the sense that right from the beginning of the year there were this entire argument which was going on in the Delhi High Court regarding this particular topic. Yes, and it's now in the Supreme Court, right? So there is a likelihood that it might just appear in your paper as well, right? So I thought let's start with something which has been in news, and you need to have a little bit of clarity on that particular concept. So if you look at this concept of marital rape, अब marital rape news में क्यों आया? सबसे important बात है भाई, ये IPC का section involved. Which is the section involved of the IPC? Section 375. Now 375 basically gives you the definition of rape, right? So what we are concerned with here is not really the definition of rape. So I'm not going to discuss in detail that what all would be included and what all would not be included in the definition of rape. That's for another class. But what is important right now is that when you are looking at Section 375, it carves out an exception. Exception kya hai? Exception 2, which specifically says that sexual intercourse or sexual acts by a man with his own wife not being under the age of 15 years is not rape. Right? So very specifically, this is something which has been created as an exception. Now, this is what was under challenge in the case of RIT Foundation versus Union of India. This was going on in the Delhi High Court, right? I'm sure most of you have read about this judgment and how there was a dissenting judgment between the two judges who were sitting together and giving a judgment. So quickly, a quick quiz. Tell me, what is a bench when two judges are sitting together? What is it called? What is a bench when you have two judges sitting together called? Quick. And this, this just to ensure that you guys are with me. Quickly tell me, what is it called? It's a very simple question. I think all of you would know the answer. Yes, Anna, you're right. It is known as a quick. It is known as a division bench, right? So if it is a bench of judges in which two judges are sitting together, it is known as a division bench. Always remember. So because, these are certain things which are taken for granted when you are reading a miscellaneous passage. Because that is what we realized from last year's paper also. There were certain terminologies which they expected you to know, right? So something like a division bench, they would expect कि आपको पता होगा कि भाई दो judges बैठे हैं तो उसको हम division bench बोलते हैं. Similarly, you must have heard of the term constitutional bench. What does the word constitutional bench mean? Any clue? Two judges sitting together is a division bench. How many judges constitute a constitutional bench? Quickly. So when we are looking at a constitutional bench, how many judges are sitting together in the constitutional bench? There would be Good. There would be 5 judges. Good, Hasika. Good, Anna. There would be 5 judges, and this is provided within the constitution itself. It is not something which which has been created by the judiciary or something or any other law. The constitution itself provides that if there is a important question of law and there are 5 and it needs law, to be looked into seriously, then you can have 5 judges sitting together, and when 5 or more than 5 judges sit together, that's known as a constitutional bench, right? So it's not just 5 or more. Minimum should be 5. Of course, there can be more than 5 also. That would be a constitutional bench, 5 or more than 5 judges. Chalo. That was something else. We come back to the RIT Foundation versus of India. So what happened in this case, there was a split verdict, right? The 2 judges who were there, they give dissenting opinions. One of them was pro the exception 2, which is there to section 375, which means he said that fine, whatever said and done, this is something which is an important exception carved out. So this is a constitutional exception. It is not unconstitutional, because of which there was a split verdict, right? Because he was more keen on the fact that, this is something which would act as a tool of harassment for people and things like that, So he had his own set of arguments. And of course, on the other hand was Justice okay, the names are here on the slide. When you look, I'm so sorry. When you look at who were the 2 judges, see, when you are looking at perspective of legal reasoning ke perspective say, what is the name of the judgment? Not relevant. What are the name of the 2 judges? Not really relevant. But when you look at it from the legal knowledge perspective, because when you're looking at your GK, in GK, there is no restriction as to GK cannot come from legal, especially in AILET. In CLAT, we don't see much of legal GK coming in the GK section, but yes, we do see it from the perspective of AILET. From the perspective of AILET, we have seen questions in which name of the judges are asked, names of the cases, important current legal cases kind of things also come, right? So Anna, your question, ki ma'am, do we need to remember the names of the 2 judges? I would recommend important cases mein judges ke naam thode se yaad rakh lo. Not for CLAT, but for AILET. CLAT में इस टाइप के क्वेश्चन नहीं आते हैं. That's not the trend which is there in CLAT. Reasoning के perspective से yes, this concept is important. Knowledge के perspective से AILET के लिए I would recommend जो important case laws हैं, names याद कर लो, and you should also remember the name of the judges. You do get questions in that. ठीक है? So those of you who are favoring AILET, those of you who are really keen on AILET, I know, before there are a lot of students who are from the north, especially Delhi, unko to NLS Bangalore se zyada AILET pasand hota hai na? So if you're in that category, I would recommend please ye cases ke naam yaad rakhna. ठीक है? चलो, moving on from there. So you had these 2 judges, Justice Rajiv Shakdar and Justice Hari Shankar. Rajiv Shakdar was the one who was pro removal of the exception, which means he said that bhai exception jo hai wo unconstitutional hai. It is something you are creating a distinction between a woman who has been who is married and a woman who is not married. So is it possible that every time there is sexual intercourse between the husband and wife, the woman is giving consent? Because the entire concept of rape is based on the concept of consent. So is it a good reasoning to believe, or is it a good assumption to make that if you are married, you are always, as a woman, giving consent to the sexual relationship which is happening between the two? That was the big question. In fact, since there was a split verdict, what happened was the matter has now gone to the Supreme Court, right? So if you look at what is written here on the slide, it says that both the judges agreed to grant the certificate of leave to appeal. अब ये क्यों important है? अब ये एक concept आ जाता है of how can you appeal to the Supreme Court. राइट सो देखो छोटी छोटी न्यूज से ही कॉन्सेप्ट्स निकलते हैं एंड इन कॉन्सेप्ट्स के ऊपर ही आपके क्वेश्चन बनते हैं. सो यू हैव दिस कॉन्सेप्ट ऑफ ग्रांट ऑफ सर्टिफिकेट टू लीव टू अपील, व्हिच मींस दैट इफ from the High Court you want to go to the Supreme Court to file an appeal, and you want that appeal to be a matter of right, which means that when you file the appeal will actually be heard by the Supreme Court. You don't have to convince the Supreme Court कि भाई मेरी बात सुनो. अगर आपको कन्विंस करना पड़े सुप्रीम कोर्ट को कि भाई मेरी बात सुनो, and the Supreme Court exercises its discretion कि fine, I listen to you or I will not listen to you. What kind of jurisdiction of the Supreme Court am I talking of? Can you tell me quick? What kind of jurisdiction of the Supreme Court am I talking of? See, this is where the interface between your current legal and your your knowledge of whatever you've done in your classes, your legal knowledge comes into play, because that is how CLAT works. If you've seen the papers, even the miscellaneous section papers, they are not purely miscellaneous. They're somewhere or the other touching upon things you already know. So if you are talking about a kind of appeal from a lower court, when you go to the Supreme Court, and the Supreme Court has the discretion whether they will listen to you or they will not listen to you, what kind of jurisdiction are we talking about here? Appellate jurisdiction, I am being told, बच्चा appellate jurisdiction तो normal appeal है, वो ये वाली appeal है जो हम बात करते हैं, that is the appellate jurisdiction. What I am referring to is what is known as SLP. When I write SLP, then everybody will like, yeah, of course we knew that. SLP क्या होता है? Special leave petition. Now this is a kind of jurisdiction which the Supreme Court exercises in cases where any case across the country, किसी भी forum में हो, you can directly go to the Supreme Court against any order of the court. So any order of the court, your special leave petition, you can file before the court. अब यहाँ पे SLP में क्या होगा? SLP में Supreme Court has the discretion whether they really want to listen to you or they don't want to listen to you. If they feel that the case before them requires some application of mind, there is an important question of law involved, because Supreme Court mein you have to realize that it is not just always based on facts. Generally the questions which are taken up by the Supreme Court are those kind of cases jahan pe there is some important question of law which is there. तो question of law को जब उन्होंने decide करना है, कोई decision देना है, वहां पे अगर Supreme Court को लगता है कि this is a case which involves that, then they will agree. Otherwise they will not agree. तो SLP हमेशा कोर्ट की डिस्क्रिशनरी पावर है, राइट? तो ये डिस्क्रिशनरी पावर है सुप्रीम कोर्ट की, whether they will listen or not. Whereas if you look at this, here it's saying agreed to grant certificate to leave to appeal, which means here instead they are talking about appellate jurisdiction. Appellate jurisdiction में whenever you want to go to the Supreme Court, you have to first get a certificate from the High Court. If the High Court feels कि भाई हाँ कोई important question of law है, then they will grant you a certificate and you can go to the Supreme Court in the appellate jurisdiction. फर्क क्या होता है इन दोनों में? यहाँ पे डिस्क्रिशनरी पावर होती है. हियर इफ यू आर टेकिंग द सर्टिफिकेट एंड देन गोइंग टू द हाई कोर्ट, देन इन दैट केस the Supreme Court will have to listen to you. वहां पे उनके पास discretion नहीं होगा, they will listen to you, right? So that is when it is the appellate jurisdiction. ठीक. अब यहाँ पे क्या हुआ कि भाई जजेस को भी रियलाइज हो रहा था कि बहुत इंपॉर्टेंट क्वेश्चन ऑफ लॉ है, तो उन्होंने बोला दैट वी विल ग्रांट यू द सर्टिफिकेट of leave to appeal, right? So therefore, then there is this Khushbu Saifi versus Union of India. This is what was filed before the Supreme Court, and here is the case in which the Supreme Court has issued notice. Right now, what is happening is this particular case, the court is looking into it, and the Supreme Court has not given a final decision yet. Right, so this split verdict is what is open, is being challenged before the Supreme Court right now. Right, Supreme Court ने notice issue कर दिया, मतलब Supreme Court ने proceeding शुरू कर दी है. They've asked the government to give their opinion. Right now, this matter would be taken up next year. I think somewhere February की कभी date लगी है इस case में. That is when the case is going to come up before the Supreme Court. ठीक है. अब यहाँ पे let's just discuss in a little bit about this Section 375. Section 375, if you look at this exception 2, it talks about sexual intercourse of man and wife, fine, and there's an age given here, wife not being under 15 years. Now, this was the age which was given under the IPC. Is this age still the correct age? Is this what the law is right now? Can anybody tell me? I'm sure आप लोगों ने ये टॉपिक के बारे में पढ़ा होगा, आप लोगों ने अपने नोट्स बनाए होंगे. Can you tell me, is 15 years the age which is the age included as per this exception as of now, or is there some change in this age? Is there some change in this age, या ये age इतना ही है? If you look at this age has changed. Okay, this age has changed to the extent that it is not 15 years now, it is 18 years. You know, there's this challenge in this particular case, Independent Thought versus Union of India. This was the case in which this particular age was challenged. They said that, you know, whenever you are talking about rape in general, and especially whenever you're talking about the POSCO also, POSCO is your act which relates to prevention of sexual offenses in children, right? So you have the POSCO Act, and you have otherwise also the concept of rape under 375. Consent normally is supposed to be not consent till the time you are 18. Anybody below 18 is, even if you give consent, it is still considered as rape. It is still considered as an offense even under the POSCO Act. So the age there is 18. So the question which arose in Independent Thought versus Union of India was that in all other laws, the age for giving consent is 18, and just because a girl is married, so here between the age of 15 to 18, it is presumed, and there is a presumption in law that she has given consent. Therefore, you know, this was again, अब ये क्या affect कर रहा है आपके Article 14 को, because this is saying कि Article 14 and Article 15 Clause 1, right? Because 14 and 15 specifically state by way of this law cannot discriminate. 14 state, on there is no reasonable classification when it comes down to creating a classification कि भाई 15 to 18 के बीच में अगर तुम married हो, then it is not rape. 15 to 18 के बीच में तुम married नहीं हो, then it is going to be rape, right? So there was this arbitrariness which was there. There was no reason, there was no logic behind having this distinction. Therefore, in this Independent Thought versus Union of India case, ये जो age है, from 15, it has now become 18. Right, so now they say that so therefore now they say that even if you are married, it has to be above 18. Okay. Okay, there's this question: consensual relations minus criminal. See, that's a different argument. When you look at POSCO from that angle, yeah, that's a different argument. But here, when we are looking at it, we are looking at it from the perspective of this exception. Anna, you are right there, but that's a different controversy altogether. What she's talking about is the fact that it's under scrutiny that you've made rape under 18, no consent. That means if there are two consenting minors who are in a sexual relationship, then that would actually amount to rape, right? So that particular controversy is also open. That's also is in question right now, right? But here we are talking about vis-a-vis marriage. ठीक है? चलो. अब लेटेस्ट डेवलपमेंट क्या हुआ है इसमें? देयर इज दिस केस कॉल्ड एक्स वर्सेस प्रिंसिपल सेक्रेटरी ऑफ हेल्थ फैमिली वेलफेयर डिपार्टमेंट blah blah blah. Now in this particular case, the question here was not about section 375 rape. Rather, what was in question here was the medical termination of pregnancy act. Ab the medical termination of pregnancy act ke under, normally there are certain specific people, certain specific circumstances, women, jahan pe you have been given the right to terminate your pregnancy even after 20 weeks. Normally, the MTP Act gives you a right to terminate pregnancy within under 20 weeks, and there is a window of 20 to 24 weeks for specific people. When you were talking about rape survivors is one of those categories, or if there is some sort of a medical risk involved, then so there are these certain categories, and one of the most important categories jinko 20 to 24 weeks ka window milta hai ki aap isme bhi apna medically terminate kar sakte ho pregnancy, are rape survivors, sexual assault survivors. Now the latest judgment is a September 22 judgment, in which the Supreme Court has said that a person, if has been a victim of marital rape, also will get the protection between 2024. So in effect, what are you doing? You are here recognizing the concept of marital rape, right? Because otherwise it is considered that, okay, you are married, so there is no rape. So once 20 weeks passed, you cannot terminate your pregnancy. But here is the place where the courts have recognized that between 20 to 24, even if you are married, and if you were raped by your husband, then you can have you can go ahead and medically terminate your pregnancy, right? So this is something which is latest. And in fact, the CJI, when he gave the judgment, he was not the CJI. He was the one who was on the bench which gave this particular judgment. Now, important thing though, what they said was that when they gave this judgment, they said कि भाई constitutionality जो है ये 375 के second exception की, we are not giving a judgment on the constitutionality of 375 exception 2. Right, so we are not giving we are not saying that exception 2 is unconstitutional. They said that we are limiting our judgment only vis-a-vis the MTP Act. So far as the MTP Act में जब आप rape survivors की बात करते हो, वहां पे हमने married woman को भी include कर लिया है, right? So therefore this is like, it just shows that maybe the Supreme Court is actually leaning towards the fact that marital rape should be included within the concept of rape. Those are the views which are, or that is what that's the kind of feeling you get when you see a judgment like this coming from the Supreme Court, right? So this is the last news which is so far as the marital rape is concerned in this year. ठीक है? So far so good. Okay. Chalo, now we move on from here. From here, we will move on to the next topic. This was your marital rape. I hope it's clear now. Very, very important. I would recommend read up on this, right? Read up on the concept of rape, read up on the concept of marital rape. थोड़ा सा अपना knowledge gain करो, अपने notes बनाओ इस topic पे. This has been in news throughout the year, so it might just be there in your paper in some form or the other. Take. Okay. Now, the next topic which we're going to do is one rank, one pension. Okay. Now, when you look at the concept of one rank, one pension, again, I'm sure most of you have done this for your GK. GK में के point of view से बहुत important है. This controversy has been going on for a long time. But we are looking at it from the legal reasoning perspective today. So when you look at one rank, one pension, what does it mean? Basically, what it refers to is that if you are an ex-serviceman, this basically refers to the defense services. If you are an ex-serviceman and you are all of the same rank with the same length of service, then you are entitled to the same pension irrespective of when they retire, right? This was the original demand when OROP started, right? So OROP का था कि भाई अगर आप एक पर्टिकुलर रैंक से रिटायर हो, मान लो यू हैव रिटायर्ड एट द रैंक ऑफ लेट्स से अ कर्नल, right? So you retired in the year 2000 with, let's say you had put in about 20 years of service. You had put in 20 years of service, and after putting in 20 years of service in 2000, you retired. And when you look at a particular pension is usually calculated on the last drawn salary by the officer, right? So whatever was the last drawn salary, the percentage of that becomes your pension, right? So let's say in 2000, this fellow was getting a pension of about 20,000 rupees, right? Now, what happened? There was another guy with the same 20 years of service, a colonel in the army, and he is now he is retired in, let's say, 2020. And the pension he gets now is 50,000. Why? Because over the years, there is an increment in the salary which happens. So as per his last drawn salary, his pension is going to be 50,000. Now, this disparity was too wide. This is the reason why this demand for one rank, one pension came about. They said that both these people have retired at the same rank. Both these people have put in an equal amount of service. Then why is it that the pension is so different? This is why there were a lot of, you must have heard of so many rallies, so much of agitation which was there. And finally, the government, even when they were fighting their elections, at that time also, in somewhere in your 14 elections, at that time there was a lot of hue and cry, and the government was like, yes, we will give you one rank, one pension, right? So the government did give one rank, one pension. But this one rank, one pension, here was not given to them in the way they wanted, right? What they had wanted was कि भाई जितना अगर 2000 में कोई retire है, 2020 में कोई retire हुआ है, your pension should be exactly on the same lines, right? That was the demand of OROP. But अब government ने किया क्या? Government ने किया, they brought in one rank, one pension, but what they did was they allowed for equalization of pension every 5 years, right? Which means that instead of it being that every time a person retired, every time there was this, a pension which was there, it is not going to be every year. If there is a change in the your salaries, every year there will not be a revision of the pension. Rather, every 5 years, it would be taken into account, and then it would be seen ki bhai, if there are people, if let's say there are 100 people with the same pension, with the same rank, with the same service and all that, that equalization process will happen every 5 years. Now, this is something which the people who wanted OROP, they had kind of revolted against, and they went to the Supreme Court and filed a case, right? Supreme Court upheld the OROP policies of the government. Supreme Court said कि भाई जब इन्होंने 2014-2015 में, even when they promised, even in the agenda they promised that okay fine, we will listen to the we will go ahead and implement OROP, the government did not agree to the exact condition what you wanted, right? So it's not that the government was bound to do whatever was told to them, right? So therefore, the Supreme Court has actually upheld the government's policy. So they said that every 5 years, if you are trying to equalize it, that is something which it would be not invalid. Now, the reason why they had gone to the Supreme Court was under Article 14 and Article 21. Article 14, they said that this classification which was being created, that for 5 years, there would be discrimination. So let's say in 2010, somebody retired, and the equalization the person will have to wait for 5 years before the pension is equalized, right? So let's say he retired in 2010 and equalization 2009 mein hua tha. So here he'll have to wait for 4 years before the equalization happens again, right? So court said that these are policy matters, and very important, Supreme Court does not want to interfere in all executive matters, right? These are small things which become important. There is a lot of hue and cry nowadays. You hear so many times that the Supreme Court is going beyond its powers. The judiciary is overstepping its limits. So these are the kind of judgments which tell you that it's not always correct. Right. So when you look at this judgment, OROP, they took a back step and they said that no, this is an executive policy. We are not really going to go and give a judgment on this. There are no constitutional rights involved here. So even though you are saying that there is a classification happening, court held that this classification was reasonable enough. It is not possible that every year it happens. 5 years is a reasonable time. So this court was considered this to be a reasonable classification, right? And similarly, when they were talking about Article 21, they brought in right to life and right to livelihood, that their right to livelihood is getting affected here. And also the fact that if 5 years it takes for equalization, there is a lot of, okay, Anna here has written ki bhai inflation hota hai, price rise hota hai, all that has to be taken account. So they said that equalization is happening every 5 years. So you can't really say that your right to livelihood is getting affected directly, because every 5 years, the equalization process is taking place. So even your Article 21 does not get affected, right? So 21 bhi nahi affect ho raha, 14 bhi nahi affect ho raha. There is no constitutional right involved. It is just a matter of executive policy. Therefore, we are not going to look into it. Right? So these were some of the points which were taken. So obviously, this no constitutional right. So there is no legal mandate which the servicemen have. Right? So therefore, the court did not interfere in this OROP, and it has upheld the OROP policy of the court. Right? So now these topics generally are your GK topics, but यहाँ पे जब ये constitutional angles आ जाते हैं, तो आपके reasonableness and all these come into play, and this again becomes a part of your legal reasoning as well. Right? This is the reason I always recommend to everybody कि भाई constitution जो है वो अपना strong रखो. Right? बाकी चीजें, बाकी topics is one thing, but have a good grasp over your constitutional law subjects. There are a lot of miscellaneous topics, lot of topics जिनसे constitution के questions बनते हैं. And in fact, till about 2020 paper में इतना constitution नहीं आया था. If you look at the last 2 years papers, 21 and 22, and even if you look at the sample papers, you would realize there is a lot of stress on constitution. Right? So I would recommend कि भाई constitution को अच्छे से तुम लोग revise time and again करते रहो. ठीक है? Sneha ma'am, if there is a violation of 21, if there is a violation of 21 and 20 or 14, then Supreme Court is not reluctant. The reason Supreme Court was reluctant in this case was that they said there is no violation of 14 and 21. 14 because they said कि भाई reasonable classification है. If you remember, reasonable classification में क्या है? आपका intelligible differentia and rational nexus. तो इन्होंने बोला कि भाई this is reasonable enough. Now the it's not as though they are not giving one rank, one pension. The only thing they're doing is that they have created a 5-year structure. Right? So that's a policy decision, because it's maybe practically for the government doing it yearly, because what they wanted was an automatic thing, that automatically it should function. But instead of having an automated system, which they wanted under the OROP, the ex-servicemen, the court said it is a policy decision, whether they want to do it automated or they want to do it every 5 years. And doing it every 5 years also, court considered to be a reasonable thing. Right? So that is why they were reluctant, because 14 and 21 दोनों के दोनों ही effect यहाँ पे नहीं हो रहे हैं. Okay, chalo. So this was about OROP. A lot of stress on constitution here. Okay, let's move on to the next topic now. So when you look at, अच्छा राजू, okay, not an issue. Hindi English हम mix करके बोलते हैं इसीलिए, so it's not that we are stuck with one language. ठीक है, चलो अब नेक्स्ट हमारा टॉपिक है इर्रिट्रीवेबल ब्रेकडाउन ऑफ मैरिज. अब इर्रिट्रीवेबल ब्रेकडाउन ऑफ मैरिज जो है वो टॉपिक काफी दिन से it has been in news because of the fact कि this is something which time and again has been used by the Supreme Court to grant divorce. There's not just one. I've given you two examples here. This R. Srinivas versus Shamletha ka judgment. Ye Munish Kakkad, Nidhi Kakkad, ye 2019 ka judgment tha. Now, these are judgments jahan pe bar Supreme Court ne under its power under Article 142, right? 142 ke andar, this court has given divorce on the ground of irretrievable breakdown of marriage, right? Now, when you look at this ground of irretrievable breakdown of marriage, what does it basically mean? I'm sure all of you must have come across this concept. Kahin na kahin pada hai. Is this a ground for divorce as per any of the marriage laws in our country? A Muslim marriage law to codified nahi hai, usko chhod do. Uske alawa, chahe aap Hindu marriage उठाओ या पारसी या आप if you look at Christians, is irretrievable breakdown of marriage anywhere given as a ground for divorce? No, right? So statutory wise, there is no ground of irretrievable breakdown of marriage which has been there, right? But time and again this has been used by the Supreme Court. Ab ye hota kya hai when they say that marriage is totally unworkable, इमोशनली डेड, बियॉन्ड सैल्वेज, हैज ब्रोकन डाउन इरिट्रीवेबली. मतलब कि शादी में अब कुछ बचा ही नहीं है एंड यू वांट अ डिवोर्स. नाउ नॉर्मली व्हेनेवर यू आर लुकिंग एट granting of divorce under the HMA are given on either on fault grounds, ठीक है, या फिर कुछ fault grounds होते हैं. अब fault grounds क्या होते हैं? Like you have the ground of cruelty, adultery, this person has been missing, desertion, has in Hindu law it is even if you convert from Hindu to any other religion, तो वहां पे किसी ना किसी पार्टी की गलती होती है. There is somebody at fault, then it becomes a fault ground and you can file for a divorce. So usually you have fault grounds कि आपने गलती करी है आपके spouse ने, therefore you are getting a divorce. दूसरा ground होता है when you are talking about mutual consent, that both the parties agree and decide कि भाई हमें divorce चाहिए. So either there is a fault on one of the parties or there is a mutual consent कि दोनों parties जो हैं they want a divorce, then that is going to be divorce by mutual consent. Now these are generally the grounds on which is divorce is given across across cultures. चाहे आप Hindus में देखो, Christian में देखो, आप generally these are the two things जिनके ऊपर आपको divorce मिलता है. अब यहाँ पे क्वेश्चन आता है जब irretrievable breakdown of marriage का, that neither do you fall in fault grounds nor do you fall in the mutual consent department. अब दोनों में से कहीं भी fall नहीं कर रहे हो, still you want a divorce. That is what irretrievable breakdown of marriage basically is, right? So time and again there have been cases जहाँ पे Supreme Court ने बोला है that even though it is not a ground for divorce, so ideally divorce should not be granted on that, but in order to do complete justice, they have said under Article 142, ये जो extraordinary power होती है Supreme Court की 142 के अंदर, कि Supreme Court कोई भी order pass कर सकता है, whether there is a law to support it or there is no law supporting it. Otherwise normally आप किसी भी कोर्ट को देखो, जब भी कोई जजमेंट देनी होती है, जजमेंट is always based on certain law. क्या अपनी मन मर्जी से just to do justice कोई कोर्ट जजमेंट दे सकती है? नो. अगर कोई और कोर्ट ये करेगा तो हम बोलेंगे भाई ये कोर्ट के jurisdiction के बाहर जा रहा है. कोर्ट is acting beyond its jurisdiction and that decision will actually be struck down. But Supreme Court, which is the supreme apex court of the land under 142, has the right to do complete justice. And under this right to do complete justice, Supreme Court has time and again been granted divorce on irretrievable breakdown of marriage. In fact, ये जो दो judgments हैं यहाँ पे, in these judgments, one of the parties does not want a divorce. Like even in Munish Kakkar versus Nidhi Kakkar, here in this case, the wife did not want to give divorce to the husband. Only the husband wanted a divorce on the ground of irretrievable breakdown of marriage. Because अगर दोनों divorce चाहते हैं तो mutual consent में आपको divorce मिल जाएगा. But here one of the parties is not willing and the other party is saying. But the court here under 142 has given a divorce. So in fact, this action of the court of giving divorce on the ground of 142 is being questioned now. अब ये Shilpa Sailesh versus Varun Srinivasan, this is a case which is pending before the Supreme Court. एक constitutional bench का case है ये, and the Supreme Court has now reserved judgment on this, which means कि इसमें सारी जो arguments है सब कुछ खत्म हो चुकी हैं. अब इस point पे judgment आएगा whether the Supreme Court even has the right under Article 142 to grant divorce. Because in effect जब आप complete justice करने की बात कर रहे हो, आप complete justice एक party के लिए कर रहे हो, that's the big controversy. The other party who is not wanting divorce, उसको divorce दे दिया गया है in the garb of doing complete justice, right? So this itself is in question here. So when you look at 142, क्या question में है, let's understand. First, it says issue that whether under the court has the power under 142 to dissolve marriage where there is irretrievable breakdown, but one party is not consenting, whether the Supreme Court really has the power to do this. Then the next thing, what they are looking into is, they are saying there are two more issues which need to be decided. What are the two more issues? First says, what could be the broad parameters for exercising power under 142? Because here you are not referring to the family court and there is no mandatory period, because normally if you look at 13B के अंदर एक 6 महीने का cooling off period बोलते हैं इसको. There is this cooling off period which is there, which is prescribed under the HMA. HMA बोलता है कि अगर मान लो 2 consenting adults हैं, हमने decide कर लिया आज हमारी बहुत लड़ाइयाँ हो रही हैं, there are 2 people who are married and they feel they're not happily married, they decide कि हमने mutually agree कर लेते हैं दोनों कि भाई हमें divorce चाहिए, right? So you go to the court and you file a case of divorce by mutual consent. अब court ऐसे में क्या करता है, immediately divorce नहीं grant करता है, because end of the day the idea is that if you are married, then you put in the effort to at least, maintaining your marriage for a while. So in order to promote that, what law has done is it gives you a 6 months cooling off period. इसका मतलब है कि भाई 6 महीने के लिए आपको जो है court will say that continue with your marriage for 6 months. अगर 6 महीने तक आपको लगता है कि you still don't want, then in that case you come to me again and then we will proceed with the matter, right? So there's a 6 months of cooling off time that maybe आपस में सुलह हो जाए and that divorce might not really happen, right? So that is your cooling off period. अब ये बोल रहे हैं कि जब आप 142 के अंदर divorce grant कर रहे हो and you are granting divorce under let's say 13B, because जब भी ये grant होता है they say that they are giving divorce on the ground of mutual consent. So वहां पे जो 6 months का cooling off period है, that period, that mandatory period under 13B is not being given to the parties here, right? So that is not there. Next, it says, and whether the exercise of such jurisdiction under 142 should not be made at all, or whether this exercise should be left to be determined in every facts of the case. So the idea is it that it will be dependent on the facts of the case that they will give, that they have the right to grant a divorce, or should they not be given the right to grant divorce under 142 at all? So this entire power which is being exercised time and again by the Supreme Court under the garb of Article 142, that is what is being challenged end of the day, right? That's the basic point कि भाई 142 के अंदर Supreme Court irretrievable breakdown पे judgment दे भी सकता है divorce की या नहीं दे सकता है, ठीक है. ओके, काजल हैज अ क्वेश्चन हियर. शी इज सेइंग, मैम मेंटेनेंस भी मिलेगा if she is not giving consent to divorce? See, maintenance is something else. Maintenance is granted to a wife even if she is not willing to give a divorce, right? So when there is a contested divorce, if you say that the fact that she is not agreeing to give a divorce, would it mean that she'll not get maintenance? No. That ways, तो अगर आप ऐसे करोगे then तो wife तो blackmail ही हो जाएगी. The poor wife will be pressurized into giving a divorce. So maintenance is something else and granting a divorce is something else, right? In fact, यहाँ पे इसीलिए you have those two concepts also which come in when you talk of marriage. You have this concept of judicial separation and you have the concept of one is judicial separation and the other is restitution of conjugal rights. All those kind of concepts also come in yahan pe, because that is where maintenance, the question of maintenance is that in restitution of conjugal rights, you're saying the wife is not coming and staying with me, so I will not give maintenance. But it doesn't work like that, right? Even if the wife is not staying with you, maintenance has to be given. Even if you want a divorce, wife is not agreeing, the court may still ask you to grant maintenance. And ye wala jo maintenance which is there, which is given while the case is going on, is known as maintenance pendente light. This is known as maintenance pendente light. Maintenance pendente light kya hota hai? The maintenance which is given while the case is going on. तो जिस समय केस चल रहा होता है उसको हम बोलते हैं maintenance pendente light, generally referred to as an interim maintenance, right? तो ये होता है आपका interim maintenance जो कि आपको मिलेगा while the case is going on. तो आपको even if the divorce is contested, आपको ये maintenance मिल सकता है, ठीक है? So I hope this is clear. ठीक, चलो. Now these were the topics which I had in mind to cover today. Now we would be taking up next a couple of more topics like this. There will be some topics you've heard of, but we will have a different angle to them. We will add the legal reasoning angle to all those topics that we do. Okay, I hope this session was helpful to you guys. If anybody has any other questions on what we've done till now, कुछ नहीं समझ में आया है, राजू भाई आपको कुछ जो नहीं समझ में आ रहा था, अगर आपको पूछना है तो आप पूछ सकते हो, ठीक है? And we would be doing these sessions regularly, like I told you guys. So stay tuned. This is going to be like a Thursday to Thursday. Now we've finished off with the miscellaneous laws ka marathon. So now what we have is going to be a marathon on your current legal knowledge, right? तो हम इसको थोड़ा डिटेल में करेंगे ताकि आपको सब कुछ समझ में आता रहे, ठीक है? जितने हमारे previous sessions हैं, the links are there in not in this description box, but you can go to the YouTube channel clatpossible.com and you would be there. Okay, Anna, you're asking about equalization. But equalization means that when you are looking at one rank, one pension, what does it mean? That चाहे आप 2005 में रिटायर हुए हो या आप 2020 में रिटायर हुए या 2022 में रिटायर हुए हो, they want that pension should be the same, right? Now, equalization means that instead now somebody retires in 2022, his pension, let's say even if equalization happened in 2020, so till 2020 जो 2005 वाले की pension अगर let's say 20,000 थी, then 2020 वाले की भी 20,000 है, because equalization happened in 2020. Now somebody is retiring in 22 at the same rank with the same service, this person is drawing a pension of 25,000. Now here, what equalization every 5 years would mean, that instead of every year automatically these pensions being revised, what their demand was that every year ये जो पेंशन का है ऑटोमेटिक रिविजन होते रहना चाहिए. what has been decided by the गवर्नमेंट इज हर साल हम इक्वलाइज नहीं करेंगे, बट एवरी 5 years इक्वलाइज करेंगे. सो लेट्स प्रिज्यूम अगर 2020 में इक्वलाइजेशन हुआ है, द नेक्स्ट इक्वलाइजेशन विल हैपन इन 2025. तो ये 2020 से 2025 तक दिस गाय इज गोइंग टू गेट 20,000 ओनली. इन 2025 then equalization will happen again. तो अब यहाँ पे मान लो 2025 तक सबकी पेंशन 30,000 हो गई है. So now everybody will get 30,000. So that is what equalization is. That every 5 years it will happen. It will not happen automatically every year. Okay? Chalo. I hope this is clear. Okay, great. So okay, so this is where we come to end to today's session. Next session we'll pick up some new topics of current legal affairs, something which have been hot and happening in this year, and we'll understand how questions will be framed. Now somebody was asking कि मैम questions कैसे आएंगे. बच्चा इसमें questions आएंगे आपके concepts के ऊपर. Now what you would have realized कि बहुत सारे constitution के concepts आएंगे. ठीक है, तो generally law में amendment क्या हुआ है, या Supreme Court का judgment क्या है, what was held, what were the contentions, that is the kind of a passage which would be framed. So with understanding कि concept क्या था, court में क्या issue हुआ था, you would be in a better place to attempt that question, right? That's the reason why we are having these sessions. Okay, chalo then. Thanks a lot. I'm glad this was of help. Now, those of you who are my students, I'm sure you enjoyed it. And those of you who are, seeing this video for the first time, who are new to our channel, just a little brief background. We are Clat Possible. We help students prepare for the Clat entrance exam. That's the common law admission test. If you're interested in preparing for it, then, these are our handles on social media. You can always contact us. We have very interesting stuff which happens on YouTube. Also, there are daily GK updates and things like that. We have weekly legal sessions, Thursday to Thursday. We've covered tons and tons of stuff on the same. You can go to the Clat Possible channel on YouTube and you will find, content to your liking. I would recommend you do that if you like this video. And you can always meet us next Thursday. Every Thursday, 7 p.m. is when we meet. Okay. Thank you so much, everybody. And lovely to see you guys here. Okay. Bye-bye. Take care. Best of luck for your prep. Not much time left. Okay. Take care. Study hard, everyone.